This is a discussion and a panel discussion for, in relation to the publication of a new book, which you will see in front of you, International Disarmament, A Guide to International Disarmament Law by Stuart Casely-Maslin and Tobias Wessner. And it's my great pleasure to have both of them here with us today, who will discuss a little bit about the elements of the book, the dimensions that are in it, but then we'd like to go ahead a little bit broader and discuss aspects of where are we in the dimensions of international disarmament law today, what are some of the key trends, but also what are some of the key challenges and opportunities that international disarmament law faces. I'm particularly happy because Stuart and Tobias, we had last year a discussion with a very distinguished professor of international law from the UK, and she mentioned how international disarmament law is a very under-researched topic and is often not featuring in university curricula on international law. So I think this alone makes this book a particularly valuable and helpful framework going forward. But also I think because this is a time in which international law across regimes, whether it's human rights, whether it's treaties, whether it's laws of war, are facing challenges and are under some degree of threat. So it's not particular to disarmament and arms control that those threats are there, but it is being felt particularly as we see in the debates over chemical weapons convention, as we see in debates over JCPOA and the INF and the way forward for new technologies. So it's a great opportunity for us to discuss this. I can say that we at UNIDIR have been involved, I think, in supporting you in this book, but we have very much benefited from it already, and I know that Dr. Jamie Revel and the team and working on looking at compliance and enforcement challenges have very much drawn on it. So we already are finding it of great use, and I hope others will too. To maybe start our discussion off, let me just pass the floor to Ambassador Felix Baumann of Switzerland to say a few words, and then I think we will have a moderated discussion, setting a few questions to Stuart and to Tobias to help us share a little bit about what's in the book. Then we are benefiting from the presence of both member state, Andrei Belousov, not a stranger to many of you here, from the mission of the Russian Federation, and from Dr. Silvia Cattaneo, also not a stranger to many of you, previously of the Italian mission to the Conference on Disarmament, but currently with the Geneva International Center for Humanitarian Demining. So it's great to get those expert perspectives, state and civil society research perspectives. So without further ado, let me pass the floor to you, Felix, and very much welcome to you and to everyone here on the panel today.
Well, thank you so much, Renata, and nice afternoon to all of you. It's a real pleasure for me to see you again after the holiday break, and let me also join Renata in wishing to all of you a successful and happy 2020. I would like to thank the GCSP and UNIDIR for organizing this event on the occasion of the launch of the guide on international disarmament law, and for having me invited today to say a few words. And actually I would have loved to stay a little bit longer, but another commitment waits for me, so I will have to leave just afterwards. When we are talking about consolidating and reinforcing international law, then obviously Switzerland has a keen interest in this, and that's also a reason why we have, the Foreign Ministry of Switzerland has been supporting the efforts leading towards the publication of the book that will be presented today. So for a country like ours, like Switzerland, I mean, we consider that the international order established after World War II around the UN Charter, based on rules rather than power relations, marked a fundamental development. The international system based on respect for and compliance with the rule of law is key in guaranteeing the security of all states, and including especially smaller ones. Arms control and disarmament treaties are central components of this international rules-based order. A fabric of rules, norms, obligations, and commitments was developed in different formats since the establishment of the United Nations, and is one of the There's an interesting graph towards the end of the book, which shows in an impressive way the huge array of domains covered today. Disarmament instruments have been key in addressing the threats posed by weapons of mass destruction. Biological and chemical weapons are banned, nuclear proliferation to a large extent contained. Likewise, arms control and disarmament treaties play a central role in addressing the humanitarian impact of conventional weapons and save human lives every single day. But this international rule-based order and fabric of arms control and disarmament treaties are confronted with a number of important challenges today. These have different causes. They are linked to the fact that some major players seem to favor the law of the strongest to the preservation of existing instruments, to the increasing disrespect for well-established norms and treaties, and as Renata already said before, to the increasingly rapid developments in the area of science and technology with direct relevance to international security and disarmament, to mention just a few. It is in this context that Switzerland has an active record of promoting and supporting these multilateral and rule-based processes in the field of disarmament. And as I said at the very beginning, this is why we have supported the Guide to International Disarmament. We believe that this book constitutes a timely contribution for consolidating knowledge on disarmament issues and to equip policy and decision makers with essential insights. It seems to fill a gap, at least I think I don't know of such other book. I don't think one exists, at least not in such a concise and overarching form. And so we now have a comprehensive overview of the international rules that govern disarmament efforts, together with brief explanations. So once again, thank you, first of all, to the two co-authors of the guide, Professor Stuart Casey-Meslin, as well as Tobias Wessner from the GCSP. Thank you again to UNIDIR. Thank you, dear Renata, for having invited me today. And I just hope that this guide will so contribute to our efforts to ensure compliance, implementation, and further development of international disarmament law. And with this, I wish you a very fruitful discussion.
Thank you very much, Felix. It's good to have you here with us, and of course, Switzerland as such a driver and supporter and at the foundation of international law. I should note just before we begin the discussion that today's panel discussion is an open event, so you can tweet or cite as you wish, and the details for access to Wi-Fi or anything is on the screen, so please feel free to engage. But now we will start the discussion going on, particularly perhaps beginning with maybe a bit of a discussion of what's in the book and how we might think about using it. So I'm going to kick off proceedings by welcoming Stuart Casey-Meslin back to Geneva. You were here, Stuart, for many years at the Geneva Academy, but you are now at the University of Pretoria, honorary professor there. So maybe, Stuart, we've heard about the challenges for the need perhaps to make a stronger case about the value of rule-governed order for states and for the pursuit of states' well-being and their citizens' well-being. But could you maybe share with us a little bit about the structure and the content of this guide and how those examples and cases are drawn out in it?
Thanks very much, Dr. Duran. Thank you also to UNIDIR for sharing its expertise during the project. Thank you to Switzerland for supporting it, and to my co-author and friend Tobias for masterminding it. We felt that there was a real gap here, as the ambassador has mentioned. About 5 years ago, Tobias and I wrote a briefing paper for the Geneva Academy of International Humanitarian Law and Human Rights on a draft of the Arms Trade Treaty. And it wasn't a very detailed commentary, but it was a paragraph by paragraph discussion of the draft that came out of the first session of the diplomatic conference. And we tried to describe what we thought the draft provisions were saying, some background on the law, and we dared to suggest some improvements. At the second session, we were very pleased to see that a lot of delegations were carrying it around with them, and lots of red scribble over it, as you'd expect, but nonetheless, it seemed to be a valuable document, and indeed a number of diplomats came up to us and said, this is very useful, this is the kind of thing that we need to see. So after that, we got to thinking, maybe there's a need for something broader, something more, I wouldn't dare use the word comprehensive, but something more detailed on disarmament law. And that was really the birth of the project. Those of you who work in disarmament or arms control or non-proliferation or related regimes will know that the leading volume, I would say, in the past has been Joseph Goldblatt's Arms Control, a tremendous piece of work, but one that dates back to 2002. There was a very interesting piece by John Kierulf, a very experienced Danish disarmament diplomat, that came out a couple of years ago, just before we started writing in detail the disarmament guide, but it was quite a personal, very interesting, but a personal review of the law and of diplomacy, and not what I think we felt was missing, which was a summary of the key treaties, the key provisions. The big decision from the outset, which focuses on the structure, was, do we go the route that I initially thought was the best one, which is to go treaty by treaty? You want to know about the Anti-Personnel Mine Convention, you want to know about the chemical weapons, whatever it may be, you go to that chapter and then you read it. And in peer review, we were told that is not going to be the most helpful document. Yes, that will be useful, but actually what you need to do is to break it down by themes and to work across the different treaties. Some of you in this room, I know, have expertise in weapons of mass destruction treaties, others in conventional weapons, some with expertise in both, but very often it's quite a niche area, even within disarmament, which sadly is quite a niche endeavor in itself. So that, I hope, explains the reason that we structured it in the way we did, by a theme focusing on development in one chapter, on use on another, the interrelationship, as was mentioned, with IHL, on production, on transfer, a tricky issue given that the different treaties either don't have a clear definition or the definition is different depending on the treaty. So we decided to go for a structure that was more thematic than specific to the treaties, and the readers will tell us if we made this right decision. Thank you.
Thanks very much, Stuart. And already I think that elicits a lot of interest in discussing for those who work across the regime, as well as for those in quite specific areas. Tobias, I think you've also thought about a mobile application for the book and for the research that you have. Do you want to maybe briefly describe that?
Well, thank you very much, Renato, and again, thank you to the organizers, to the colleagues, and everyone who is here, and also especially you that take your time at this noon. Yes, we created also a mobile application that complements the guide, but I think most importantly, it's not about a guide, it's about offering you a digital tool that you can use to have timely and accessible information in your everyday work. And if you don't mind, I'm just going to switch to the computer so I can give you a brief overview of the application. So what are we basically talking about? We're talking about disarmapp.com. So we handed out a small card as a hint, but it's pretty simple. It's disarmapp.com. And what are we really talking about? We're talking about a web-based application that on the one hand you have a disarmament map, and I'm sorry that it's not bigger on the screen. You have a treaty database, you have themes, major themes of disarmament, you have definitions, acronyms, and of course something about the project. So if we start right away, and Ambassador Baumann has mentioned it, with the disarmament map, it's the small icon that unfortunately you can't really see well, but it's really the illustration of all major relevant disarmament treaties or disarmament-related treaties, which it's structured, you can't see it, but here it's conventional weapons. You can see all the instruments regarding cluster munitions or mines, for instance. You can go on the other side, you see weapons of mass destruction. Here it's clustered by theme, nuclear weapons, biological weapons, chemical weapons. If you go down the nuclear route, you see the testing, like the CTBT, the PTBT, etc., the NPT, the bilateral treaties, the regional treaties, or the TPNW. Or the same thing here with biological and chemical weapons, with the Australia group, the export control regime, BWC, CWC, and the Geneva Gas Protocol. So it's really a holistic map that maybe helps you to orient yourself how the different instruments fit together. But also, if you spot one, you can look where it is, or the other way around, you can get really a holistic view of what's out there. And of course, you can download, or you can do as we will do now, you can close it. Here on the application, it's the same thing, just broken down. If we go down the route of weapons of mass destruction, you can go like, for instance, chemical weapons, and you'll see all the relevant instruments or treaties. Talking of CWC, what you'll find is the full document. So here, really the original document. What you also can find is the status of the treaty with ratifications, etc., and a fact sheet that are linked or done mostly by authoritative sources, fact sheets on the treaty. So you'll find for every single instrument, you'll find the full document, the status, information on the status, and the fact sheet. Now you have the same thing as a database, so in a chronological order. So if we're going again to the CWC, you see 1992, you have the full title here of the document, full document, status, fact sheet. So you really have everything together with accessible with a couple of clicks. Then the themes, well, here, for instance, the major key elements of international disarmament law, if not international disarmament efforts in general. You can say, for instance, destruction of used weapons. You'll find information here, general analysis, but also then a list of actually which treaties have provisions regarding that theme. So you can get an overview and eventually also known sense of what you think worked and what didn't. Same thing for definitions. Here, for instance, you can go down to disarmament or weapons and arms, the different arms definition. Like here, disarmament, what the different definitions are. And not last, but almost, acronyms. So the list of all these weird acronyms. We hope that if you're confused, you can find it. If not, please let us know. CWC, again, just Chemical Weapons Convention, so just a list of acronyms. And the last is just some information about the project in itself. And I think this is really a good opportunity to thank Routledge, the publisher, for its support throughout the whole entire project, and especially the Swiss Confederation, the Federal Department of Foreign Affairs, which really funded the 2 years of research and even plus 1 year of additional work to make it accessible, etc., and also today's event together with UNIDIR. So again, thank you very much. And with that, thank you.
I think I speak for everyone in the room to say this is an incredibly valuable tool to have that one-stop shop that can be really useful, and I expect, I look forward to the enriched discussions and disarmament forums as a result of that tool. But maybe if we can maybe just start to look at the themes that you've explored in this book, Tobias. You know, what you've shown us is just the importance of disarmament treaties as instruments, and to some extent the multiplicity of treaties, of how rich the international disarmament body of law is and has developed after World War II. And as you pointed out, Stuart, some are targeting one set of things, whether assistance to civilians or to victims. Others are regulating aspects of relationships of behavior between states. Could you maybe share with us some of the trends that you've identified from the existing disarmament instruments, either key inflection points or key developments that you've noted in the course of this guide and preparing this?
Yeah, thank you very much, Renata, and really interesting question. I think talking of trends, I think if we look at the whole treaty making, the disarmament treaty making, we can see since the end of the Cold War kind of three phases. And I think maybe the first phase is the Cold War. The second phase is like this golden age of treaty making. And maybe I would argue there is a new phase, today's phase, regarding the making of disarmament treaties. Now, The Cold War treaty making, or let's say this period, I think was really marked, as you've mentioned, by building the blocks, the major blocks of international disarmament law, of building the foundations. I'm just thinking of the BWC, the NPT, CCW, etc. So I think also from a procedural point of view, maybe it was hard to achieve agreement, but also you had broad adherence that came out of that process and really set the basis. Then the second phase, I would argue, would be like a golden age of disarmament treaty making, like the 90s, right? We see a rapid development of international disarmament law, thinking of 92, CWC, 98, Anti-Personal Mine Ban Convention, 2008, CCM, etc., etc., etc. So you have the tendency there in that phase, actually, to have a non-universal treaty making, but also kind of non-universal adherence. But what you definitely have is a rapid norm development through that, let's call it, golden age, because a lot was possible. And then we have the new phase, and here, let's say it's smaller groups of states that actually find agreement and that push something forward. I'm really thinking of the 2017 TPNW. Now I think at this stage, early 2020, good moment to reflect on these questions. I think it's hard to say, is this the end of the old phase, where the group of like-minded states gets smaller and smaller, or actually are we seeing a new phase, a small groups of states putting themselves together and really pushing agenda, pushing a disarmament forward, and that can be great powers, non-great powers, however, but is this a new phase of smaller states, or it's actually just the end of the last phase and the groups are getting smaller and smaller and smaller? I think that's up to discussion. But with these three phases, what is important, I think there are overarching trends, there are major trends that overspan those different phases. And one is the application of treaties from only in wartime to any time. A second is focus on the weapons effects on civilians. A third is there are standard key elements to treaties. And a fourth concerns the threshold for the entry into force of disarmament treaties, quite technical, but still a trend that is out there. So maybe quickly on RL4, on the first application of treaties. Originally, as Renata has said, the regulation of weapons came through international humanitarian law. So the branch of law that said, hey, we need to regulate a war, there are even rules even in war times, and that was the law that regulated then the use or even the accessibility of weapons. But that over time has evolved, and what you now have with more modern treaties is that the prohibitions to use weapons actually doesn't only concern wartime, but any time and any circumstances. So that is like in itself a development. And what this also makes is, number one, it's more holistic as a regulation, and you're not getting into the technicalities of armed conflict or not. But what you're also getting into is like international disarmament law kind of breaks out as an independent legal field or even a legal branch of international law. But so you have a focus on the outright ban of weapons. That's the purpose of modern treaties. And this leads a little bit to the second point, which is the focus on weapons effects on civilians. So if you look at more modern treaties, you don't have as a primary concern anymore those of states as state entities as such, or even international security, but more civilians. So neither states nor soldiers, but actually a focus on civilians. And like the anti-personal landmine or the cluster munitions, well, you say they can't distinguish between lawful targets and civilians, so let's just take out the entire weapon from the battlefield in order to protect civilians. So that explains to you the rationale and the structures of treaties, but you can also see that in operational provisions such as victim assistance that really targets that goal. Third point, maybe taking a bit of a step back again, is I would argue that the time of framework agreements like the CCW seems kind of over. What you really see is standalone treaties that really address a topic or even a weapon type as such in a holistic and comprehensive manner. And these standalone specific treaties then, as Stuart has mentioned, really contain key elements that really have become standard key elements. And those are mostly elements on stockpile destruction, transfer, development and testing, production, and use. So you really have standard key elements there. And the treaty in itself is complete and regulates something in a complete manner. And the fourth, as I said, a very technical aspect, but still relevant, and I think especially relevant for states, concerns the entry into force. And here we see that the threshold of ratifications necessary for entry into force of treaties has actually changed. So in general, what we see is a tendency that the numbers of ratifications that are necessary for entry into force have actually diminished in the treaty. So CWC, there had to be 65 states that ratify in order to enter into force. The APM-BC, so Anti-Personal Mine Ban Convention, 40, the CCM even 30. So a little bit, you see the numbers are getting lower in general. And what, of course, you also don't have anymore is nominal thresholds. So what you have in the BWC or the CTBT, namely certain states have to adhere in order to make the treaty enter into force. That was abandoned in more recent practice. So again, technical, but still relevant from a legal perspective. So those for tendencies, application of treaty to any time, not just wartime, focus on weapons effects on civilians, the third, standard key elements of standalone treaties, and the fourth, threshold for entry in force. So those are like the trends of the last 70 years, and I would say that the trends of the future, well, that's in your hands. Thank you very much.
Thanks very much, Tobias. That's absolutely fascinating, and I'm sure there's going to be a good bit of discussion on your description of the sort of trends and the phases, not least, as you pointed out, the TPNW is a small set of states, but of course there's quite a large set of states that signed up, and it was within the framework of the UN, unlike questions like the Ottawa Convention and the Dublin Convention. So that'll be interesting to compare and contrast. Andre, I'm going to turn to you now from a state's perspective, as Tobias said, one of the people making the law, and one of the actors making the law.
And one who is breaking the law.
And breaking the law, indeed. It's always useful to remind ourselves of that. I think, we see that disarmament treaties, and of course it's an obvious point, but an important point, that they're the product of international diplomacy and the product of long, often painstaking negotiations between and among states. And of course the Conference of Disarmament that exists here was set up exactly to facilitate those long and often detailed discussions. But today we see a much larger spectrum of actors involved in discussions of regulation. We see private sector, we see civil society groups, we see expert perspectives, so-called epistemic communities. So I think that's a real factor that it would be very interesting for us to reflect on, how we think about lawmaking in a world that is no longer the sovereign preserve of states. How do you see these challenges and these developments? Is the main challenge new instruments? Is the main challenge compliance of instruments? Is the main challenge how we think about who gets to make the instruments?
First of all, thank you very much for the invitation to participate in this event and to speak in front of such a distinguished audience on this very important for the international security theme, actually. And thank you for your questions. They are not so simple as they seem to be, but I'll try to share with you my opinion and my vision of these issues which you raised right now. So first, the multilateralism and the participation of the civil society and private sector, industry or commercial organizations in the elaborating new or discussing or considering new instruments in the sphere of arms control, non-proliferation and disarmament. So right now it is already the reality. It is not the question of the future or the possibility. It is already the reality. It is reality in New York. It is reality in Geneva. It is reality. I mean, the appropriate arms control and disarmament fora, and it is a reality in Vienna. So the civil society, the industry, the private sector is already participating in the consideration of this very vital for all humankind issues. So, and definitely by providing specific expertise, by generating some new ideas, by providing new ways and means which are helping to the states to fulfill their obligations under specific treaties, the civil society, the industry, this wide range of actors will definitely contribute positively in what we are calling the international efforts in the sphere of arms control, non-proliferation and disarmament. And definitely they will, by this, they will assist us, I mean the states, to generate new instruments, the ideas on new instruments. And I agree with Tobias that there is already the system of the set of, so to say, common specific elements of such instruments which we can use in our work and rely on them, on this set, while we considering such of this specific issue, definitely. So, where are the limits of the role of the civil society and actors like civil society in the sphere of arms control and disarmament, if there are any limits, of course? I suppose that the role of civil society and private sector is limited by the jurisdiction, the exclusive jurisdiction of states. What I mean, you are absolutely right that each treaty in this sphere is the product of very serious and complicated compromise. But it is not the compromise between the states, it is the compromise between national interests. So, each time this compromise is determined by the wide range of factors, the main of which is the military political situation in the world. So the states have the exclusive obligation in supporting, strengthening, and preserving international security at different levels, local, regional, and global. So this is the exclusive jurisdiction of states. And using this exclusive jurisdiction, states determine the, so to call, disarmament agenda. Moreover, they take the obligations under specific treaties and must fulfill them. So definitely all these specific obligation and specific functions of the states limited the participation of the private sector and civil society in the process of the elaborating new treaties. But once again, I would like to stress that right now the participation of the civil society, the wide range of new actors in the international efforts in arms control and disarmament is a reality. You can find the references to the specific roles of industry and civil society in many documents, UNG resolutions, for example. So that's the reality. So we can discuss about the role, about some limits, but the participation of the civil society is already the reality. And we would like to find the proper ways how to say, how to use, sorry, the eagerness of the participation of the civil society in this process. So as to the two second questions, so I will try to not to overcome my time limits, but definitely I would say that right now the international community face difficulties in both spheres, in the sphere of fulfilling the obligations under specific treaties and in the sphere of elaborating new commitments. But here I would like to be more specific, not on elaborating new commitments, but on elaborating new instruments in the sphere of arms control and non-proliferation. But these difficulties of different categories, the first category of difficulties which is connected with the compliance with the specific treaties could be overcome by the mechanism, but the traditional ways and means, politically diplomatic ways and means, and by using the mechanism which are already contained in some of these treaties. So there is some mechanism and procedures how to overcome, to discuss, to settle down all these issues. Another problem is the elaboration of the new instruments. That's I suppose that's we face more difficult challenge, so to say, and if we try to address it, the first thing we should do is to come to the common understanding of the ways and means to provide, to strengthen, and to enhance international security at different levels, local, regional, and global. So in 60s of the 20th century, we reached, I mean, the states reached such an common understanding, and this understanding was materialized in the decision of the first special session of the United States General Assembly on disarmament in 1978. Right now, this concept, this common understanding is under the revision, and there is risk that the result of this revision will be in the result of that, of such a revision, we can lose this fundamental basis for our international efforts in the sphere of arms control and disarmament. So thank you.
Thanks, Andrei. And I think you raise an interesting level about the different, or an interesting point about the different levels of applicability of law, local, regional, global. And you also raise, I think, some interesting comments about the relative balance between compliance of existing instruments and new challenges, which I think we'll return to in a moment. But I'm going to turn to Sylvia now. Sylvia, you've stood in the civil society mobilization, you've stood in the academic space, and you've stood in the member state space. So you have an opportunity to comment on all those perspectives. But I think we heard from Tobias that one of the trends in the 1990s was this move towards the human at the center, the implications of the effects of weapons. And so what some people called humanitarian disarmament, other people called human security perspective. What do you see as the experiences of that? What has been the pros of that approach? What are the negative aspects of that focus on the effect and on the human at the center? And how do you see this relationship with this much more emphasis on people, on how that links disarmament to other processes that are underway, including in this town, whether human rights, whether SDGs, sustainable development, and others.
Thank you, Renata. This relationship between humanitarian disarmament and human security is interesting in the sense that human security is what lies at the foundation of humanitarian disarmament. We wouldn't even be talking about humanitarian disarmament if we hadn't had this tremendous shift in perspective, which happened more or less in the mid-1990s, when for the first time a UNDP report spoke about the necessity to focus on the well-being of individuals and not just of states. And since then, this idea that the safety of individuals should not necessarily come first, but certainly shouldn't be neglected, has been at the core of several disarmament processes and negotiations. Some Tobias mentioned already, so the conventions on banning landmines and cluster munitions, but it also played a key role in the adoption of the Program of Action on Small Arms and Light Weapons, partly also in negotiations of the ATT, Arms Trade Treaty, and even in the CCW, which is a forum that was born essentially to balance the imperatives of international law, international humanitarian law, with military necessity, the idea that you should safeguard individuals from risks of explosive ordnance are at the core of Protocol 5 discussions, for instance. If you look at all these processes, it's very difficult to deny that these were successful. These were essentially success stories, some more than others. Clearly, implementation is not, at the same level across the board, and you have some treaties ahead than others. And actually, in one instance, you have the Program of Action on Small Arms, which is not even a treaty; it's a political commitment. But it's undeniable that they have spurred a lot of movement in very concrete terms, and this has had very positive effects, I believe. And it's even more striking if you compare and contrast this with what's happening in other, or what has happened in the past decades in other areas of disarmament, typically but not exclusively closer to WMD and to more traditional notions of security, where the situation in some instances is of stalemate, if not even reversal today. Now, negative aspects. If you ask states, probably there are many negative aspects of focusing on individuals, but simply because for a very long time, the idea of focusing on people, on communities, was seen as a contradiction to instead preserving the interests of the state. But later on, I will give you the example of the mine action sector, in which instead we managed to bring together these two and to go beyond this dichotomy. Now, what I think that the power of human security, besides the fact that for once it wasn't a concept that was born in an academic sector, it wasn't, a theoretical concept. It came out of political circles. It was taken up by UNDP, well, invented by UNDP, but then taken up by states that were central in the negotiations that I mentioned before. Its power resides in the fact that it allows us to look at the same things but in a different way. So suddenly it allowed us to see that all these components that you mentioned, peace building, human rights, economic rights and what have and development, they are part of one same idea, one same goal, and that they're not in contradiction and conflicting. It's interesting to see this through how the example of how the notion of the relationship between disarmament and development evolved. Now, today it's very common to talk about this relationship, but it's definitely not a new idea. I mean, the 10th special session of the GA dedicated to this link took place in 1978. The first international conference dedicated to this relationship took place in 1987, and GA resolutions on the issue go back at least 20 years. However, if you look at the narrative of these early initiatives, it was peculiar and was definitely very different from today's. The essential reasoning was the more you spend on weapons and the least you can spend on development, which, by the way, is an equation which has never been proved in reality, that if you free up resources from disarmament, they will be invested in development. But conceptually, the idea was if you want to develop more, you have to be less secure. And this put these two in a conflicting and in fact even almost in an inverse relationship. Now today this reasoning has been completely overturned, and we've come to see that these two elements, disarmament and development, are in fact in a mutually reinforcing relationship. And I believe that the concept of human security worked as the unifying factor in this. Human security basically allowed us to understand all these activities: peace building, sustainable development, humanitarian assistance, demining, disarmament at higher levels with different kinds of weapons, all as part of one same effort to essentially free people from want and from fear. And I will come to the concrete example of the mine action sector, in which, well, I work, but also because it's an interesting example in which these activities were born essentially as disarmament activities, but then developed in links to broader agendas. Initially, the community in mine action was very much focused on weapon-related outputs: how many weapons you destroy in stocks, how many landmines or clusters you clear from land. And increasingly, for the past few years, the community has started to see itself as an enabler of pretty much everything else that you need for states to get back to recovery, to peace, and to long-term resilience reconstruction. Concerning sustainable development, the GICHD and UNDP in 2017 published a study that showed that mine action can have a direct or indirect impact, influence on pretty much all the SDGs, on 16 out of the 17 SDGs. And obviously this link, you have to make this link, and the most appropriate way of making this link is to start streamlining mine action into the sustainable development strategies and plans that countries have to develop at the national level. And this is something that countries have been, a few countries have been already engaged in. So I'm not claiming that this is the example that should be transferred as is to other disarmament issues, because obviously each one will be specific. But I think it could be a source of interesting lessons in terms of going beyond what I mentioned before, the traditional dichotomy between state and human security, and start to identify comprehensive responses to complex challenges like the ones that we face today.
Thanks so much for that, Sylvia. And I think you link up to a point Tobias made about the holistic nature of treaty making increasingly. And then, of course, it begs the question, how much can a treaty hold, and what is the scope and the scale for us thinking about how comprehensive to be. It's also great that you mentioned this link between disarmament and development, because it's come back up again in the question of the Sustainable Development Goals, and I think it's very important for us to revisit, as you said, that link. I'm going to ask the final question to Stuart now, and then I'm going to open the floor for questions. So do please put up your flags, and I'll try to see you. Apologies if I don't know you by name. Please introduce yourself. And feel free to engage, particularly the younger and people. This is not a hierarchy, but do please engage. But Stuart, I'm going to maybe ask you maybe just to take a step back and thinking about the future that I think Tobias hinted at, and Andre raised questions about the new challenges. But from a legal perspective, what are the current challenges? And we heard about political will, and we heard about scope, and we heard about new technologies. But from your perspective as a legal expert, are there lessons, are there challenges that we can already identify, and are there lessons that we can think about that might help us in navigating these newer areas?
Thanks very much. I speak to you as an unadulterated and unashamed lawyer. I am not a diplomat, as many of you in this room will know. I do not claim to have diplomatic skills. So the first point to make is this is not an advocacy document. This is not a, you should go out and do this, you should go and do that in the future. It is, as the name suggests, a guide to help people who are working on treaty making or soft law or whatever it may be. But that said, let me make one, hopefully not too provocative, legal statement. Constructive ambiguity is the friend of the diplomat. It is not the friend of the lawyer. And I suggest to you that in the long term, it is not necessarily the friend of international law and international relations either. Now, I realize that this treaty-making process, inherent in it, is compromise. And I don't decry that, and I don't dismiss compromise. But we have seen in treaty after treaty where ambiguity has been deliberately left in to get the agreement, so with good intent, but yet years afterwards we're still squabbling about what we thought we agreed to. So if I can make one plea, is that I hope that in future the definitional issues will be given as much consideration as is possible in the circumstances. The second issue, looking forward in new technologies, you're aware of them, and many of you will be aware of the legal challenges, if not the practical challenges. Cyber, artificial intelligence, which is going to change our lives in ways we haven't even begun to comprehend, and of course, within autonomous weapon systems. Tobias, Sylvia and I were teaching on a short disarmament course late last year, and one of the last exercises that we did was to ask the different groups to draft parts of a treaty prohibiting autonomous weapon systems. And there was some good work and some good thinking in a limited period of time, but we also saw the immense challenges in technologies that have legitimate, peaceful, positive purposes. That said, it's not as if we haven't been here before. The Biological Weapons Convention recognizes that there are legitimate purposes for certain toxins, for certain naturally occurring biological substances, as does the Chemical Weapons Convention, as do the treaties on nuclear weapons. Nuclear energy, we know, it's the pillar of the NPT. It's reiterated in the TPNW. So it's not as if we haven't been there in a difficult scenario where we want to prohibit, eliminate, prevent the nefarious elements of technology whilst preserving the positive, the peaceful, the humanitarian aspects as well. I don't minimize in any shape or form the challenges if we do adopt such treaties in the future. But to recap the old joke, you know, the optimist says the glass is half full, the pessimist says it's half empty, and the engineer says the glass is too big. I think that summarizes disarmament. It's a little bit of all of that. We're never going to get our general and complete disarmament from Article 6 of the NPT, but everything that we do get, I think, is probably progress. Thank you.
Thanks for that. It's a good note to end on, Stuart, and it's a good reminder that technology developments have often been a driver of arms and indeed efforts to control them and think about disarmament, so they're inexplicably linked. I'm going to open the floor now for questions. If you have a comment or question that's directed at one person, please direct it to them. Otherwise, if it's a general one, whoever on the panel wishes to take it up, please feel free. Anyone wish to be the first to kick off? I see Jamie Revel. Jamie.
First of all, thank you all. It's a really interesting panel, and Happy New Year to everybody as well. There's a question for Tobias, actually, I wanted to raise. You spoke about phases of disarmament. I wonder if you've been able to detect any associated changes or phases in practices of enforcement, specifically whether there are changes in the sources of evidence, the people involved, the processes applied. So it's really a general question on that. And actually a comment to respond to Stuart, if I may. He spoke about ambiguity in definitions and that being problematic. I wonder whether the BWC would have its enduring value without that ambiguity of definitions as to exactly what a biological weapon is, and that broad, comprehensive approach. So it's just a comment for response. But thank you all very much.
Thanks, Jamie. I'm going to take a couple of questions, if I may, and give the panelists just a time to reflect. Marc Finot, GCSP.
Thank you very much. Maybe a point that we discussed when we worked on the draft book. Of course, there is this distinction between arms control, non-proliferation, disarmament that you explained. There are definitions which actually show that the legal instruments actually leading to actual disarmament, elimination of weapons, are really a small minority of all the instruments that are mentioned and studied in the book. The rest, deal more with containing the arms race or preventing proliferation. But there's one aspect that we actually sort of never really addressed, because paradoxically, some of the most effective ways of leading to disarmament have been through unilateral action, and without any sort of legal constraints apart from national self-imposed constraints. Happens between US and Soviet Union, but also the unilateral disarmament of South Africa and reductions in nuclear arsenals of France, UK, and other nuclear countries. So could you say maybe a few words about this paradox?
Another rich question. I will give the floor now to whoever would like to take a go at those first. I don't know, Stuart, do you want to take a first shot? And given that 1 point was to you, and then anyone else wishing to comment?
Thanks, Jamie. I would be unacceptable if I were to say the exception that proves the rule, because I know there are many other exceptions out there. As I said, it was a provocative statement, but I think if you look at one or two of the issues that we've raised in the book, the definition of transfer, for example, I do not think that that is beyond the scope of states to agree in a particular treaty on a clear and unambiguous definition of transfer, and yet we've managed it in treaty after treaty. So I don't pretend that that generally applies. I just think there are instances where we are not best served in the long term. The Arms Trade Treaty, which I'll come back to in a second in relation to Mark's point, is a good example. We're still discussing what the word overriding means in English, French, Russian, Chinese, Arabic and Spanish. So was that, given how critical that word was to the treaty, was that the right way to go? It's great that we have the ATT, it's made an impact, but equally I think there are some issues there. Mark, who contributed a lot to the book and the work that we did, has raised a couple of issues. Firstly, in terms of the notion of disarmament, I should have said out front, there is a definition of disarmament in this book. It is not the definition. I would love, if we had time to workshop, that everyone in this room would write down what they understand the word disarm, or the concept, the discipline of disarmament to be, and how it differs to arms control. And I think we'd have a very rich discussion about how that simple word, beguilingly simple word, is misinterpreted or is interpreted in very different ways. And to come back to the ATT, some people call it a human rights treaty, some people call it an export regime, and the UN has it under disarmament on its treaty website. What's the right answer? I don't know. I don't pretend to have the answer. Just to say that this is partly a prism and a difference of perception. And I think you're right to flag up this notion of unilateral action. I have to say, with hindsight, it's something that we should have flagged up in the book. Because I think there are instances in relation, you've mentioned a couple. Equally, I could mention the early days before we had the Anti-Personnel Mine Ban Convention. Belgium's decision nationally to outlaw in domestic law, they had no obligation to do so, to outlaw in domestic law anti-personnel mines was a good step forward towards the adoption of the treaty. So thank you, it's an important point.
Thanks, Stuart. That's room for the next book. Tobias, the question on enforcement that Jamie asked you.
Yeah. Well, thank you very much. Really interesting, very relevant, but also extremely difficult question. And if I may do the qualifier, well, lawyers like to talk about what the law is, and maybe they want to also talk about how the law was created, but then enforcement, especially compliance, implementation, are really oftentimes questions that the lawyers type of head away from, and even maybe give it to the political scientists, because what is really oftentimes lacking in international law in general, and also in international disarmament law, is really a systematic analysis of compliance, implementation, and the mechanism, the enforcement mechanism. So Having said that, we also in the book, we did not do a systematic analysis. We really more concentrated on what the law is and eventually what the history of the lawmaking informs us. So having said that, I think also that really shows the importance of UNIDIR's work on compliance, because that is really at the heart of what's out there. What do we do with the law? Not just creating new law, but what with the law that's out there, what are we actually really doing? So my comments will really just be a little bit on things that we stumbled over during the research and the consultation. So I think on the one hand, like for the NPT, you have the great powers, in particular the US, that really had its watching hand over enforcing the NPT, and I would argue doing quite a good job. You have the UN Security Council that in particular situations worked on enforcement, on compliance, etc. I think chemical weapons use in Syria, that was a pretty strong response by the international community, which I think I remember at the beginning with the red line by President Obama, there was a lot of mockery out there. In a sense, that was just nice rhetoric, but in the end, I think it turned out really a great international cooperation that made a difference. And then going back to maybe where we're more comfortable with is with the terms of treaty making. I think here you see also again in the newer treaties much more on transparency mechanisms, on verification mechanisms, and of course also of implementation support units or secretariats. So I think there is in the treaty making there is some development that shows that actually compliance, implementation, and eventually enforcement really is taking a bigger role. And of course, a topic you've mentioned, Renato, civil society monitoring, that maybe does not do enforcement in itself, but I think the rapid increase of civil society monitoring really increases information that then allows the enforcement. So those 2 cents to that very, very difficult question, but I think also extremely relevant topic.
Thanks, Tobias, and thanks for your kind words on UNIDIR's project, which means you're immediately roped into the project. But Andrea, you wanted to offer a few thoughts before we open the floor again.
Yeah, I would like to give the short comment to the question on the unilateral actions in the sphere of arms control and disarmament. It is a very important question because, we have several examples of such actions. I just would like to remind you that the Russian Federation in the beginning of the 90s last century reduced their non-strategic nuclear arsenals for 40% and to bring all these systems of weapons on the territory of the Russian Federation, put them in stocks. Well, it was unilateral action, and you mentioned France and Great Britain. We should analyze the circumstances and conditions under which all these actions were done. It will help us to understand the real possibility of such actions in the future. That's my first comment. And the second comment, I suppose that action could be undertaken with the main goal to give some momentum to the process in specific areas in arms control and disarmament. So, for example, again, the France and Great Britain, actually gave some momentum to the disarmament process. So if we analyze the whole picture, the relations between this Russian Federation and the United States and the balance between the strategic arsenals between the Russian Federation and NATO countries, so we will understand that it was the positive moment, and really it gave the momentum to this disarmament process. Thank you.
Yeah, I think that it's an important point you raise, Andre, about the importance of incentives and understanding incentives for compliance and for the development of law and then compliance to it, as well as the interrelational dimension. I'm going to now give the floor to Richard Lenan from GDP.
Thanks, Renata. Richard Lenan from the Geneva Disarmament Platform. Thanks to all the panelists and for Tobias and Stuart for producing this book. I was also pleased to have helped a little bit with that. I have a question really perhaps identified, building on Tobias's point about the trends we see. One of the other trends I think we see quite clearly is that as we slowly over the decades accumulate more and more disarmament treaties, a greater and greater proportion of the diplomatic work here in Geneva is not on negotiating treaties, but on implementing and reviewing the treaties we already have. And I think it would be true to say that for most colleagues here in this room, most of their work is on existing treaties, not negotiating new ones. So I wondered if the panelists had anything to say about that trend and what it means in terms of how disarmament works now, if it's mainly building on and interpreting existing treaties in a way that doesn't sort of add new law, but it does have quite perhaps important practical implications for the way these treaties are implemented. And I also wondered a little bit, whenever I see a nice shiny new book like the one you've got on display on the podium, I immediately start wondering how quickly it's going to go out of date. And I don't think it's going to go out of date with respect to the information about the treaties, but every review conference that adopts a new understanding or every meeting of states parties that makes some new undertaking is something I think that diplomats need to understand. I was just thinking if you went into the NPT review conference this year, having just read the NPT itself, you'd have no idea what anyone was talking about, because most of the discussion relates to agreements that were made at previous review conferences and promises that were made and perhaps not kept. So I'm looking at your very good Disarm app. Is there any thought perhaps of expanding that to incorporate some of this more time-sensitive data so that we can keep up to date on what's been agreed since the treaty entered into force? Thank you.
Thanks, Richard. I'm going to take two more comments or questions, and then I'm going to turn it back to the speakers for a final wrap-up. John Borey, followed by Peter Kolyev.
Yeah, thank you very much to all the panelists. It's been a really interesting event, I think, and I want to commend you on the guide. I think it's an excellent resource, and I think it will have a long lifespan. I guess I have a two-part question, and the first is, I think addressed to all the panelists, but particularly the lawyers on the panel. Is disarmament law, are legal instruments and arrangements necessarily the gold standard? And the reason I ask that is because the multilateral disarmament community has got itself into a state where it can't negotiate lesser measures that might be politically binding because of its preoccupation with achieving legally binding measures. And you only have to look down the corridor at the Conference on Disarmament and its 20 years of deadlock to see that. So I'm just wondering, should we be treating legal arrangements as automatically the gold standard, or are sort of other forms of agreement that might not be legally binding, are they kind of useful, and what are their uses? And I guess related to that, the second part of the question is, for all of the panel, is what do you see, given your overview of the regimes involved in disarmament, what do you see as, if you like, the low-hanging fruit, or the agreements or confidence-building measures or other arrangements that might be ripe now or in the near future for negotiation? For instance, the extension and development of New START seems to be quite widely seen as critical over the next year or so, but presumably the disarmament community, the arms control community, can walk and chew gum at the same time. So what else should we be working on, whether it's in the conventional field or the weapons of mass destruction field? I'd be very interested in your views. Thanks.
Thank you, Renat, and thanks to Unity and GCSP for organizing this, of course, to the authors of the book. I think it's really much needed. I agree that I was thinking after Goldbright's arms control problem, there is an attempt. There are many books but they're mostly database, not really an attempt to a little bit to analyze also trends and challenges. It's not just a question, it's much more probably a comment, a follow-up of what Richard said. I believe there is also one clear tendency in disarmament treaty law from the very beginning. We know disarmament treaty, IHL, treaty law, what referred to is one of the first bodies of international law to be codified internationally. And if you look back from the St. Petersburg Declaration, then the Hague Convention and so on, the first treaties were simply norm setting. That's it. It was considered, this was the concept. It was considered that and it's still the responsibility of the governments to implement them. They are responsible, they will do that. Then it appeared that it's not the case. We have different periods of active norm creating after the Second World War, after the war in Southeast Asia, after the end of the Cold War. And then it led to an evolution of the operation of the treaty. We first moved to, we realized that there is need of a periodic review of the status and operation of the treaties because the situation was changing, because the norms were probably old, because the weaponry was evolving, the military concepts were evolving. So we moved to the next step, which was the review process, periodic, sometimes automatic, sometimes not, to go to the next step now, which is very clearly everywhere we can see that, even either in the legal drafting of the new treaties or by taking political commitments in relation with the existing treaties of operationalizing the treaties, looking at the implementation process. It's not enough to have just a review, periodic review. We have a constant process which keeps the items in the agenda of the national governments, which looks at the way the treaties are implemented. Depending on the treaty, it may go from verification to simply, or cooperation assistance like in the BAN Treaty, verification in CWC, simply creation of IHL culture in the case of the CCW. So it's different, but it's a very clear tendency that we want the treaties to be on the daily agenda every day, and we need to look at the way they are basically operationalized.
Thanks very much. I think that's a point, as you mentioned, Peter, that echoes some of Richard's questions. I'm going to turn now to the panel for wrap-up context, and I think I'm going to take a democratic, just call them this order, if you don't mind. Sylvia, any comments that you have on what you've heard?
I would like to address what John asked, both questions, if I may, even if I'm not a lawyer and the lawyer here will probably stop talking to me after my comment, but that's okay. What's the low-hanging fruit? Honestly, I don't think there are many, at least if you look at it from the point of view of multilateral processes involving pretty much everyone. At the bilateral level or small group level, you might have bigger chances. New START is still a big, question mark, I think. Probably right now, and I'm not very creative, the WIPA is one, the WIPA issue, the issue of explosive weapons used in populated areas is one that has the higher likelihood of reaching some form of formal result. I think that the political declaration process that was kickstarted by Austria and then brought forward by Ireland will have a result. The point is what that declaration will include and the level of ambition that it will have. To some extent, you have to think in the more ambitious you want it to be and the fewer people states you'll have signing on to it. So you have to keep into account this. The issues that today they're very trendy in disarmament are as Stuart also mentioned before, are incredibly complex also from a purely technological point of view. You have cyber issues, artificial intelligence, laws, etc. And I don't think that this will go, at least not formally, very far for the time being. But this also brings me to your first question, which is a legal treaty, is a treaty the gold standard? And in disarmament, I would say no. I would argue, and this is where you will hate me, in international law, I think that the line between law and politics is very, very fine. And especially in disarmament, where most of, That's okay. In disarmament, where a lot of treaties have no teeth, essentially, so there is no way of imposing anything if they have been violated. Well, whether that's a treaty or a political agreement or a commitment or a declaration, it doesn't really, in my view, make much of a difference. And I will actually give a concrete example on this, which is small arms and low weapons, because I think it's one of the rarest instances in which the political process, in my view, got stuck in the sense that it got repetitive very soon. Very early on, we had touched on all the issues that were safe to touch on, and the red lines that were there in 2001 are still there, and politically it's not progressing. But for the past 20 years, it has worked as the source of legitimation of such an extent of activities at all levels that it's basically impossible to keep track of them. So, yeah.
Okay. Thanks, Sylvia. Stuart, your thoughts on any of the things, including Sylvia's comments?
So I will take time out to unlike Sylvia on my Facebook page, so I'll be down to 3 friends, unfortunately. But let me pick up on the example that you gave and suggest why I think it's actually the opposite conclusion to be drawn from it. I remember a decade ago being harangued by SALW activists. Why is it you mine action people get all the money? And I said the answer is we've got a treaty and you've just got a little bit of paper. And it does make a difference. I'm not saying that there is no value to soft law, because I'm going to give a couple of examples where I think that there has been value. But I think in that specific instance, and we know the reasons, we know why we don't have a treaty on this, I think that was a strategic error. And I think that the problem of SALW has not been addressed sufficiently and has not received sufficient support from donors, because there isn't a treaty as there is with mines and with clusters. But in response to your question, absolutely there's a role for soft law. The Safe Schools Declaration hasn't changed the world, but it's moved us forward, and maybe it was just not possible. I have my doubts about a WEPA, but it's worth a try. I don't say that it's doomed to fail, because maybe it isn't. And if we look back in time, human rights, core human rights on the right to life and freedom from cruel, inhuman or degrading treatment is interpreted by reference to a soft law document that was adopted by states in 1990, not a treaty, but that's what human rights courts and other bodies use to interpret what is arbitrary deprivation of life. So soft law, most definitely, including in disarmament, can provide an important role. I just don't think that small arms is a particularly good example of that, personally. Richard's points were very good. If you're correct, Richard, and there's something of a stasis in disarmament law going forward, if there aren't the low-hanging fruit that John was mentioning, then the book as such won't go out of date quickly. But you're right, there are important review conferences, meetings of states parties, conferences of states parties, and so on. And that's why the app, I think, is so valuable, because that can be updated very readily, very quickly. A book, obviously, a little bit more complicated to do. But I actually think it was great that we did it when we did, and maybe not wait, because I'm not sure there's going to be a tremendous flood of new thinking coming out of the MPT review conference. I hope I'm wrong.
On a timely note, Andre, I'm going to ask you if you have any final comments.
With our limits in time, just 2 small comments. First of all, it is very important issue, the correlation between the political and legal elements of the treaties in the sphere of arms control and non-proliferation and disarmament. We have different example of it. For example, if we take the bilateral treaties between the Russian Federation, Soviet Union, Russian Federation, and the United States in the nuclear sphere, so definitely they are very detailed, very sophisticated treaties, and we can call them as a kind of golden standard for for similar treaties. So we have the CWC. So I suppose it could be considered as a golden standard for the disarmament treaties. So we have other examples with weak treaties, for example, the for my opinion, it's not only my opinion, but the opinion of my country, but ATT treaty, ATT is very weak, and we can't consider it as a golden standard for the arms control and non-proliferation and small arms and light weapons. So we have different examples, but actually historically the legal instrument in arms control is the most effective means to provide proper skeleton for arms control, disarmament, and so on and so forth. So, and another my comment, we can consider any measures of transparency and confidence building as only the supplementary measures for the legally binding instruments. Maybe we can include them into the legally binding instruments as a part of them, but they can't, definitely, they can't compensate the absence of the legally binding instruments on specific arms control and disarmament issues.
Thanks, Andre. Tobias, the final word on the panel is yours.
Yeah, thank you very much. So if it's the final word, I'll try to make it short. I think relating to Rich and John's comment, but also going back to Jamie, the question of soft law useful and how I think soft law is really interesting because you can get an easier buy-in by states. You can be more flexible than with hard law in that sense where you have to be very much precise. But I think actually writing the book and also some stuff going on with the ATT actually really changed my mind in the last year or so, because I do think we do, and I think Stuart shares that analysis. We do realize that disarmament is very treaty-based, a lot of really treaty-heavy. So also we really struggled. We couldn't really identify a lot of customary international law, so unwritten rules, which in other branches of law are much more easier. Also, soft law still remains, at least for norm setting, kind of less used. And I think that the reason for that is that just international law, treaties, is more precise, number one, and number two, actually it's very clear that states commit at the highest level, so most of the time involving the parliament, etc. And you can even see CWC or bilateral treaties between the US and the Russian Federation are extremely detailed, extremely technical. So the other aspect, however, with the ATT is talking about enforcement, to me something very surprising is really cases now brought forward at national courts, actually. And so you don't have this interstate enforcement mechanism, but this intrastate. And to me, that is really novel in the disarmament field, and I think very interesting and promising. But then again, talking of implementation work, etc., looking at the export control regimes, which are all politically binding, which I would argue really function very well, at least at the technical level, and really are a tool for implementation of broader principles or aims, etc. So that would be the substantive point, and maybe just, since I have the last word and views of that, really we had a couple of reviewers reviewing the guide, so it wasn't just research, it was also consultation, ranging from researchers to state government officials, etc. And I see John, I see Rich, Mark, really Sylvia, thank you so much for taking that time and really lending your time and energy into that. And also thank you, Dominica de Beaufort, for investing a lot of time in the Disarm app. That was a lot of pain sometimes, because it looks all easy and simple, but getting there is actually oftentimes very burdensome. So thank you very much for all the support, and thank you very much, Renato, for chairing this panel.
No, thank you, Tobias. Thanks to everyone for coming. It's clear there is a huge amount of interest in the topic. It's a complex topic, and there's both a rich residue of past practice to build on, but but also some interesting questions about where we go forward. Could I just note the Disarm app is a very useful tool. Perhaps we can circulate and follow up access to it, because when I put in Disarm app, I got my fitness tracker, and so it's the new year, but I don't really feel that resolution coming through. And then can I just say, for those of you interested in the book, you can download it to buy it via Amazon online. I think do have a conversation with the authors if you would like to get a copy and any further information. So to all of you, the law is the framework for much of your work. So with this, good luck for 2020, and many thanks for your company. Thank you very much to the panel. We'll give them a hand.